every person in America, and most importantly, every American citizen and taxpayer understood this fund for what it was, a corrupt effort by the President of the United States himself at the expense of the American taxpayer. That's why this is of overarching significance to the presidency. I have said already that this marks the beginning of the end of Donald Trump's presidency.
Welcome to The Stakes. I'm Brad Rourke with the Charles F. Kettering Foundation. We're a nonprofit, nonpartisan operating foundation that focuses on advancing and defending inclusive democracy. Today, I'm talking to Kettering Senior Fellow Judge J. Michael Luttig and CEO of Democracy Forward, Skye Perryman. Skye, Judge, thank you for being here.
Thanks for having me.
Thank you, Brad. Always a pleasure.
At issue is a settlement arising from a now dismissed lawsuit between President Trump and his Department of Justice. That settlement, about which there are questions, created a $1.8 billion fund that was to be used to compensate people who had been targeted by so-called weaponization of the government. That fund is on hold as the result of a lawsuit led by Democracy Forward. The Justice Department has made claims that the fund is not moving, but it has not formally rescinded it in writing, and key parts of the underlying settlement remain in place. So questions do remain. Judge Luttig and Perryman are involved in different ways. Luttig as part of a group of former federal judges seeking to reopen the IRS case, and Skye Perryman leading a lawsuit challenging the legality of the fund created by that settlement. Skye, let's begin with you. Boil your argument down, please. What do we need to know about the lawsuit that you are leading?
There's no authority for the president's slush fund and the way in which the Department of Justice has said this fund would operate. It also violates multiple provisions of the Constitution, the First Amendment, the guarantee of equal protection, and on and on and on. And so we filed a case in federal court. The judge immediately moved to pause anything happening with the fund until the court itself could review the legality of the fund, and we are getting prepared later this week for the hearing on that.
Judge Luttig, you are calling for the reopening of the original lawsuit. Why?
Brad, a number of retired former federal judges have asked Judge Williams, who presided over the initial case in federal district court in Florida, to reopen her dismissal of the case because we maintain that the United States government misrepresented the facts of the fund and therefore defrauded the court. Obviously, the government's argument was that this was a settlement between adverse parties to a dispute. It was that allegation that, of course, gave rise to a case or controversy that's cognizable in the federal court. But it is just as obvious that these were not adverse parties. This was Donald Trump as president of the United States and his government over which he presides as president of the United States. Therefore, they were not adverse parties. All of that, we believe, that is, the federal judges who have asked Judge Williams to reopen the case, we believe that's all indisputable. And we take the government's seeming abandonment of the fund as evidence of the truthfulness of our allegations.
So these two cases are they interlocking in a way that complicates them, or are they separate questions, each of which can be straightforwardly resolved?
Well, they are not interlocking, and at this point, they are two separate cases with two separate issues. Before Judge Williams, the question only at this point is whether the United States government defrauded the court in the initial proceeding. Judge Brinkema's case, she is beginning to decide for the first time whether the fund is legitimate.
Skye, is what are the other aspects of the case that you're bringing that we need to know about?
One is, I think there's a trend we've seen that's a very troubling trend with this administration, which is that the administration really is seeking to move so quickly to avoid judicial accountability. So the whole reason that the federal judge in the Eastern District of Virginia in our case paused the fund to begin with was because the Department of Justice would not agree that it would not move forward with the fund or take actions according to the fund until the courts could rule on its legality. So I think that's just an important point here. We're going to have a hearing over the legality of the fund. We are confident in our arguments that there is no authority for it and that it's operating, at least the way the Department of Justice has described it, it is operating in a completely illegitimate manner. But this is not just about the merits of the case. It's also about a Department of Justice that is trying to, in some ways, run the clock out in ways to avoid judicial accountability. I believe in that sense, you have something similar in Florida, where it's essentially the president and his allies knew that the court was likely to dismiss the case that he filed. It was a bogus case, that there was not a case in controversy, there wasn't jurisdiction. And before the court could do that, they rushed to dismiss it to try to engage in this illegitimate settlement, which is, of course, what the judges weighed in on there. So that's one trend that we see in a lot of the cases that we litigate a democracy for, that we think it's important for people to be paying attention to, for every single American to be concerned about. And here we are really grateful that the judge took the step that was needed to preserve the status quo so that the courts could weigh in, because this is an administration that is saying and doing multiple things that are contradictory in order to try to avoid accountability. And we intend to pursue that this week in the case. So those are two things I think that are really important. And then the other thing I would just highlight, which I think does speak to the diversity of people that are very concerned about this fund, is that in our case, challenging the fund, we have a highly diverse coalition of plaintiffs. We have someone that spent their career as a career federal prosecutor that worked on the January 6th cases and was targeted and fired for that by the government. We have someone that was a protester that engaged in a legitimate protest and was jailed by this administration and later acquitted, who's been targeted. We have the city of New Haven, Connecticut, that has been targeted by this administration. We have reproductive health care providers who have gone to do their jobs in the face of many violent threats that federal law protects them against, but that this fund would seek to compensate people that have pled guilty to crimes under that federal law. And then we have a pro-democracy voting group in Common Cause, all together in this case, challenging the fund for the same reasons. It's unlawful and illegitimate, but they all show different manifestations of the way this fund is so deeply harmful to many Americans, kind of regardless of what position you're in. And that's similar, of course, to what you see with the judges that have weighed in Florida. You have judges that were nominated by any number of presidents that may have any number of disagreeing views on some things, but here all have a concern about how the judicial process was being misused by this administration.
Brad, it's worth noting that this settlement, included an agreement by the IRS not to pursue any further audits of the President of the United States. The President of the United States, though he has acknowledged the possibility that his government will abandon the overall fund, he specifically said, and I believe his acting attorney general has said, that no matter what happens to the fund, that aspect that gave Donald Trump immunity from the auditing by the IRS will remain. That is to say that the entire settlement fund is still a live controversy. Donald Trump cannot hope to get out of this now until all aspects of the fund are resolved, including the auditing. Brad, that it would be impossible to overstate the significance of this one effort by the President of the United States. Essentially, if you think about it, he has rolled up his entire presidency the first time, the intervening 4 years during which he was contesting the 2020 presidential election, and his second presidency for the past year and a half into this one single act. That's why you have seen the universal condemnation of this from the moment it was announced. Why every person in America, and most importantly, every American citizen and taxpayer, understood this fund for what it was: a corrupt effort by the President of the United States of self-aggrandizement of himself and his family and his allies and supporters at the expense of the American taxpayer. That's why this is of overarching significance to the presidency. I have said already that this marks the beginning of the end of Donald Trump's presidency.
Skye, to what extent is your effort that you're leading with others potentially precedent setting, and might it actually stop future efforts that are similar?
Well, I mean, this is an unprecedented move by the president, and so by definition, the legal cases that we're bringing do address new territory. Now, we believe it's a very simple question when you look at the law. There's no authority for this fund, and there's no way in which the Constitution or other federal law permit the fund to operate the way that the president says that it would operate, which of course is what we've seen throughout this administration, is just more of the same tricks, kind of dressed up in different ways. But more broadly, what I can say is that we've seen the power of litigation and the power of the federal courts over the past year and a half really be able to push this administration at times to abandon some of its most priority initiatives. I know that does sound, it's not completely satisfying, because we know this administration has been able to proceed with so many harmful things. And so I'm not at all minimizing the harm that people have felt. But what we've seen over the past year and a half is over 750 federal court cases with an administration that is losing in court far, far more than it is winning. About 70 to 80% of the time they're losing. And they're losing before judges that President Trump himself appointed. They're losing before judges that Republican presidents appointed, as well as before judges that Democratic presidents appointed, because of the way they are operating. What we've seen in many of our cases at Democracy Forward is that the act of calling the government to account in court, forcing them to come forward and say under oath and in court filings what they're doing and why they're doing it, forcing them to defend their actions, has actually led to situations where the administration has just walked away because they don't have a defense. And so I don't have a crystal ball, but if I could, I believe that the significance of this case will be, we will continue to block this fund. But I think what this case and what the judge's brief has done, and what other efforts, there have been many cases filed on this fund, are doing in real time, is they are forcing the administration to account in a public way with rules that they don't get to set for what they're doing. And in so doing it, they're showing the American people what is happening with this administration. And that's helping contribute to the public pushback. So we're very confident this case will continue to have a good impact. And of course, we're very pleased that we've been able to stop the fund from operating so far.
Democracy Forward CEO Skye Perryman, Kettering Senior Fellow Judge J. Michael Luttig, thank you so much for spending time with us today.
Thank you.